The Miranda versus Arizona case centered around the rights of those accused of a crime. Ernesto Miranda was arrested for rape, kidnapping, and robbery, 3 crimes to which he later confessed at the end of a 2-hour interrogation. Miranda did not have an attorney present during these questionings, even though he had a 9th grade level of education and a history of mental illness. The confession was later used by the police in order to convict Ernesto Miranda of these crimes and sentence him to 20 to 30 years in prison.
So the Miranda Rights, going off a criminal suspect, should, in my opinion, should still be read to them, because in the end it covers both the agency and the suspect in the process. Most people aren't aware of the process after being arrested by a law enforcement officer. So reading the rights to the suspect is allowing them to understand what the process is after they get arrested and processed through the law enforcement agency that's arresting them.
I think Miranda Rights should be read because it gives the person being placed under arrest their proper rights, and it saves them from saying anything that would incriminate them, as well as giving them the right to attorney.
The U.S. Supreme Court established basically 2 concepts that apply as to whether or not you are entitled to have your Miranda rights read to you. So those 2 concepts are custodial, interrogation. So in order for you to be entitled to your Miranda rights, you need to be in police custody, number 1, and you need to be interrogated. So let's talk about what does custody mean. Custody, if you are under arrest, you are definitely in police custody, without question. But the second concept comes up as to whether or not you're in police custody if you're just in a situation where a reasonable person would feel as though they are not free to leave. So that would also be considered to be custody. So once you're in police custody, Miranda would apply. But we need the other part, and that's being interrogated. Now, I know on TV you see things of people being interrogated and yelled at, and there's just one light in the room, and where were you on the night of the 5th? But that's not really what interrogations are like. So interrogation simply means the police are asking you questions about a crime. So if you are in police custody and you are being asked questions about a crime, your Miranda rights apply.
I believe there are cases where the Miranda rights should not be read because these suspects might be a danger to the public safety.
And really, the police have a incentive to do it right, because if they don't read your Miranda rights, a court could later rule that your confession or anything you say to them would be suppressed and therefore not admitted, and therefore they would not be able to get the evidence. So the police do have an incentive to do it right. So in order for your Miranda rights to apply, again, let's review, you need to be in custody and being interrogated. Thanks.
The Miranda rights must be read to a criminal suspect for 3 reasons. The first one, the 5th Amendment, that assures that no criminal suspect self-incriminates himself. 2, the 6th Amendment, that assures that every criminal suspect has a right to an attorney. And 3, just so the police officer act lawfully.